So, good morning, ladies and gentlemen. Guten Tag. I'm Tianbao Qin from the Wuhan University. I'm the director and the distinguished professor of Research Institute of Environmental Law. Today, I'm very pleased to share my understanding about the perspective of China's judiciary for climate change adaptation litigation with all of you. 2020 is a big year for the environmental protection topic. Since the early year, China and the entire globe have been experiencing a bigger pandemic, which proves that the loss of biodiversity and the impacts of climate change are risks, multi-players. We are here today to explore how to effectively address these issues, particularly the more fundamental one, climate change. As it is known, China is the world's second largest economy. On one hand, China faces heavy pressures from energy security, resources supply, and environmental quality. In accompany with its rapid development, as a big emitter and responsible country, on the other hand, China never gave up its efforts of taking environment and climate actions. Actually, China has shifted its attitude to international affairs from passive responses to active commitment. Just a week ago, our President Xi Jinping made a significant announcement in the UN 75th Assembly about China's pledge to achieve carbon peak before 2030 and carbon neutrality till 2060. Undoubtedly, this ambitious climate target is all around measures involving the active role of judiciary. Moreover, carbon neutrality cannot be effectively achieved in the absence of adaptive responses and climate resilience. In fact, along with this increasingly serious threats of climate change, the urgency and necessity of adaptation become higher and higher. However, unlike the vivid practice of mitigation litigation, adaptation on global scale, the progress of involving judiciary in climate change adaptation seems slow in general. So what happened to China? What has been done to adapt to the climate change? Has the judiciary played any role in this progress? In the remaining part, I will try to display a big picture about the prospect of China's judiciary for climate change adaptation by answering the previous questions. Firstly, I generally describe China's major actions on adaptation with focus on policy instruments and the judiciary as well. Secondly, I will explore the legal sources of rights and obligations for climate change adaptation. And prominent cases illustrate later to assess the role of the public interest litigation and environmental costs in adaptive actions. Lastly, general comments will be reached on the China's prospects on adaptation litigation. So first is a very short introduction. Increasingly, adverse impacts of climate change are observed in the past decades, imposing risks on the environment and public health. China has taken top-down actions to adapt to these impacts. At the central level, National Climate Change Action Program preliminarily adopted the basic strategy of addressing climate change, which placed adaptation in an equally important position with mitigation. In response, the 13th and 14th 5-year plans of China for its economic and social development requires the integration of climate change factors into economic plannings and large-scale infrastructure constructions. In the year 2013, China's first adaptation strategy, National Strategy of Climate Change Adaptation, identified the key areas and measures to ensure adaptive capacity. In addition to that, at the international level, China submits national communication in which commits itself to developing a national adaptation policy framework. It can be found that adaptation policies come intensively and to a certain extent that interconsistent with each other. In China, these policy instruments are especially important for a new and important thing like climate change adaptation. Not only they promote responses, but also flexible and professional solutions for climate change. Particularly, some instruments work as powerful guidelines for local government actions. The targets set in the plans are theoretically compulsory according to China's environmental protection law. I will talk it in more detail later. The significance of a policy instrument also works when it comes to a judicial system. Typical examples can be found in the internal working documents of the Supreme Court, also called as judicial policy. One document is the guideline for environmental trial to promote green development, which highlights climate change litigation together with other environmental and resources-related litigations. Shortly after this, another document specified this new type of litigation into the lawsuits, respectively related to energy saving, emission reduction, biodiversity conservation, and green finance, emission trade dispute, etc. With regard to this classification, it can be easily seen that China's current advocacy for climate change litigation is primarily mitigation focused. Biodiversity and dangerous species protection served for both mitigation and adaptation litigations. Whether green finance cases have an adaptive impact remains unclear. Additionally, in practice, the Supreme Court annually released the Environmental and Resources Trial Report, known as White Paper. Herein, I'm delighted to share with you that the latest White Paper 2019, for the first time, covers climate change litigation. As this White Paper summarized, there have been emerging mitigation lawsuits in both broad and narrow terms in China. I will return to this part later. Comparatively, however, China so far has no practice about the typical adaptation lawsuits. To put it in simple, in China's practice at hand, there is no case that explicitly, principally claimed for adaptation to climate change. A more widespread phenomenon is no adaptation claim at all. If we follow the same logic with mitigation litigation, we would soon find the fact that there's only broad term adaptation litigation based on the co-benefits and the spillover of wide effects of environmental protection and sustainable development. Second, I'd like to introduce the legal basis for the climate change litigation. As just mentioned, in spite of the inadequacy, specificity, and number, positive signals have been sent throughout policy instrument timely. Unlike this, legislative response to adaptation is much slower. Owing to, as a matter of fact, the legislation of climate change is a general com-led. Owing to the broad implementation approach, China seeks to embed climate change adaptation in wider issues of green development. Substantial laws as well as procedural rules tend to accommodate adaptation lawsuits. Regarding to the substantive laws, till now, China hasn't enacted a special climate act. Only the draft had been issued for public consultation since 2012. This year, to speed up the promulgation of the Comprehensive Act and RIEL pre-existing laws are reaffirmed by the National Parliament Conference, is the China's legislature. Its legislation committee put on the legislative agenda already. Despite the lack of a comprehensive act, China's environmental lawmaking has experienced noticeable developments and become inclusive, comprehensive, and constructive. Take the mother law, environmental protection law, as an example. The latest version introduced ecological red line and the environmental health risk, early warning and assessment system. Besides this, under the overarching environmental law framework, resources laws and regulations on species protection, land use, sustainable forest management, water resources utilization provide potentially legal sources for adaptive rights, obligations, and legal liabilities. Also in China, disaster response laws attend increasing attention. In addition to this, other laws are expected to play partial role, such as the civil code. Individuals and private sectors are under these guidelines of the green principle that require environmental-friendly practice, low carbon production, and consumption lifestyle. Except for the substantial laws, the incentive advances of procedural laws bring vivid public interest litigation practices. So far, in China, there are 3 types of environmental litigation: civil public interest litigation, administrative public interest litigation, and ecological damage compensation litigation. Public interest litigation has been laid down by the environmental protection law and further confirmed by the procedure laws, correspondingly to promote specific operation. The Supreme Court respectively stipulated judicial interpretations to further support public interest litigation practice under this context. Meanwhile, China set out the road of the specialized of environmental jurisdiction. Green cause has been established at whatever levels, from the top Supreme Court to the down, the county cause level. Right now, we have more than 100 different types of environmental cause in China. So environmental and climate justice can tend to this specialized green cause, and the public interest litigation serves as crucial channel. Certainly, I'd like to share several cases to show how China's adaptation litigation runs. The first case just happened this July in southern China, where suffered heavy floods. My province, Hubei, is one of them, in which a city named Honghu. Local city procuratorate launched an administrative public interest trial against Yangtze River Road Bureau for their failures to strictly perform duties of safeguarding the Yangtze River dry wall. In this case, water law and flood prevention law were cited to implement a mandatory supervisory duty of Yangtze River Road Bureau to stop illegal buildings of amusement facilities along the Yangtze River's main embankment. According to the administrative procedure law, the procuratorate should carry out the urgent proceeding of correcting suggestion for the defendant with time limits before litigation. This is a good example of holding governments accountable for their adaptation duties in floods and extremely weather events. Another case has been presented by the White Paper 2019 and serves as a typical adaptation cases in ordinary litigation. This case deals with land use of a real estate company. Their lands overlapped with the biodiversity red line area in Haikou. Local municipal had acquired this piece of land for environmental reasons and made a compensation. Land management law had been applied in this case to justify the government's acquisition and adjust the balance between the public interest and private rights. Haikou is a coastal city with a vulnerable ecosystem that is protected strictly on the marine eco red line. Very few words about the third public interest litigation occurred in civil area and involved the fresh new civil code. Green NGO based on the civil code, more specifically the Green Principle, and the Circular Economy Promotion Law initiated a lawsuit for the fulfillment of the lease contract. The Green Principle requires that all civil subjects engaging in civil activities should assist in serving natural resources and protecting the ecological and the environment. A lessee of real estate was thus required to follow the requirement of social reduction during the entitled rental period. The case contributes from private rights perspective to preparing commercial building for the climate adaptation friendly use. Then I will give my understanding about the a little bit analysis and assessment for the practice and progress of climate litigation. As practices indicators, adaptation litigation take places in either ordinary and public interest litigation. Randomly, the ordinary case concerning land use, forest rights, and resources management may result in positive effect on adaptation. Only on the conditions that the pre-existing policies and laws have made synergic arrangements. It could be also found that the administrative cases dominated in adaptation area due to the most adaptive activities are policy-oriented and governmental-led. Nevertheless, the chance of achieving clear, complete, and scaled-up effects of climate change adaptation in ordinary case is small. From lately booming practices, there is a trend that the public interest litigation play a necessary principal role in safeguarding public environmental interests. After all, climate is a public good just like the environment. In practice, China's current public interest litigation benefits from its quick legislative response to environmental problems and sustainable development needs. According to the key areas of legislative achievements and upcoming plans, public interest litigation is most likely to contribute to adaptation efforts too. Two reasons lead to this. One is the legal barrier, especially procedural barrier, have been removed largely. More specifically, standing, the burden of proof, causation, ecological restoration provides increasingly potential for the preparation and recovery from the negative impacts of climate change. At least, eligible NGOs and procuratorate on behalf of the public can launch lawsuits against the polluters, ecological disruptors, who meanwhile harmful to the climate change adaptation in case of, for example, eco red line, coastal line activities, flood prevention. The second reason lies on the fact that more chances are offered by public interest litigation. This is particularly true in the area with absence and the inadequacy of laws. For example, right now in China, a specialized climate act is on roll. Public interest litigation is thus encouraged to conduct experimental and tentative cases in energy climate cases. In public interest litigation, the judge normally appears open-minded, flexible, and even brief on the national promotion of judicial activism. This is also why the very first climate mitigation case, Friends of Nature sued the Gansu power grid, has adopted the public interest litigation channel. Likewise, the public interest litigation aims at coastal management, land use and natural conservation, and forest management and water usage, and disaster control tend to benefit adaptation and can be categorized into broad-term adaptation lawsuit. So far, it is virtually certain that due to public interest litigation, the judiciary in China begins to play ever greater role in climate justice, including adaptation justice. The favorable atmosphere results from two significant progress. The first one is the judicial activism. Environmental courts played as a major forum of judicial activism. For example, when exercising the discretion power over open articles and vague concepts, the judges of environmental courts are likely to favor environmental-friendly understanding, interpretation, and application. But here, there is a key question. To what extent climate-friendly requirement is consistent with environmental-friendly requirement? As far as the adaptation is concerned, how climate risks are preserved, regulated, and addressed in environmental protection and sustainable development context. Besides, China's environmental courts emphasized public participation by introducing experts' testimony and a people jury system, by which better balance public environmental interests with other interests in trials. Another favorable macro environment for promoting adaptation litigation refers to the ongoing ecological civilization reform. Examples are like local governments' accountability and causal performance assessment promoted by the reform. The climate change impacts vary at the local level. For example, Shanxi province suffered from water shortage, with Qinghai province has a vulnerable ecosystem. Ecological civilization reform called for a local tailored approach and carry out the strict accountability of local government. Administrative public interest litigation, therefore, is assumed to play a supervisory role in this process. What is more, ecological civilization reform launched several pilot programs, such as a national park, environmental risk monitor, and so on. This program provides tentative and experimental examples for the broader scale and in-depth judicial responses to adaptation. In addition to this, the reform identified key priorities areas such as ecological security, environmental health, benchmarks, and disaster reduce. Public interest litigation is encouraged to have a trial in these key areas and help promote the better compliance with existing laws and shape future adaptation actions. Despite of obvious opportunities, adaptation litigation is confronting with potential problems also. Some problems are common among various judicial systems, such as the weak causation chain, how meta glaciers and sea level rise induced by warming climate are linked to the infringement of living rights to coastline residents, how to attribute certain climate impacts to specific defendants. Except for the common difficulties, China has its own problems. Firstly, there are very few right-based adaptation cases due to the absence of substantial environmental rights. The enactment of civil code helps in this regard, but only with limited areas. The lack of environmental health benchmark makes the scope of rights to health vague in eco-environmental context. Also, inadequate attention and researchers have been attached to the climate change-related human rights. Secondly, although ecological damage compensation litigation is based on the governmental ownership of public goods, the correlated public trust doctrines possess no mutual conditions in current China. Surely China, as a continental law country, does not have to introduce public trust doctrine. However, as for adaptation litigation, the dysfunction of public trust doctrine also means that the future rights and the intra-generational equity seems unlikely to be applied into supporting adequate actions against the climate risks. In regarding to this, I have to mention that China's first preventive case, it received a positive result in this February. The case successfully protected the regional habitats of green pin-falls from being destroyed by the establishment of hydro stations. The case judicially confirmed the principle of precaution that is missing in the current legal framework, having far-reaching influences in climate change adaptation lawsuits. But in the context of a lack of a precaution principle and public trust doctrine, alternatively, the outcomes for the adaptation litigation barely rely on case-by-case identification of climate risks as serious risks to social environmental society. So last is my conclusion. Finally, we come to conclusion. First of all, climate change adaptation action in China is generally governmental-led. Policy instruments like a plan, program, played a necessarily significant role in achieving climate resilience, which directly or indirectly influence courts and trials, litigants and judges. The judiciary, by cooperation, played a secondary supplementary role. The extent to which it may work depends on whether the overarching environmental law framework and the broader implementation approach would be fully and properly used. Secondly, even in the litigation which adaptation co-effects, the relevant claims are forwarded in a marginal, hidden, and prudent manner. Or basically, no claims are made on climate change adaptation initially. Whilst this case just realistically resulted in an adaptation favored way, certainly in light of China's top-down enabling policies and law environment for green development, public interest litigation as well as green court have increasing potential of contributing to the climate resilience, adaptation, preparation, and capacity building. It could be predicted that future prospective cases may occur in sustainable agriculture, disaster response, public health, and disaster control. Carbon neutrality is a bigger challenge for China. While it can also be a vulnerable chance, while it could also be a valuable chance, as long as we make best use of it and fully prepared ourselves by the integration of adaptation efforts and the active, effective, and constructive role of the judiciary. So generally, I'm very optimistic with the role and practice and prospect of judiciary of the climate adaptation litigation. So that is my short presentation about this topic. I hope my presentation will be helpful in your understanding of China's environmental law, China climate law, and China environmental judiciary. Thank you very much.